Hello friends, welcome to Insights I Can Initiative. In today's video, we are going to discuss about Muslim reservation. Okay. Before we discuss further, first let us see the topic title and the video components. The title of this topic is Reservations for Muslims, and the context is Prime Minister criticized Congress that reservations which supposed to be given to SC, ST, OBC, those reservations also some of them given to Muslims. That was the Prime Minister criticism regarding the election campaign. Okay, and it was specifically quoted the Andhra Pradesh government as well. So this is the context, and in this video we will discuss about reservations for Muslims and the issue related to Andhra Pradesh government Muslims quota and reservations reservation policies, constitutional provisions, like how the reservations evolved over the period of time, including the Champakam Dorai Rajan case, Article 15.4, and we will discuss about Mandal case, that is Indira Sahani case. What are the Supreme Court observations in Indira Sahani case? How the Indira Sahani judgment led to the development of Article 16.4a and Article 16.4b. These reservation policies we will discuss in this particular video. These are the video components. Let's see syllabus mapping. This particular topic is related to UPSC CSE Mains General Studies Paper 2, the Constitution. The context of the video is Prime Minister at an election rally said that Congress often tried to give reservation to Muslims by reducing the reservations related to SC, ST and OBC, and setting an example of providing Muslim quota in Andhra Pradesh. In Andhra Pradesh, what happened? Andhra Pradesh government in United Andhra Pradesh, the government decided to give reservation to Muslims within the reservations allocated to OBC. That means certain percentage of the OBC reservation, that in that OBC reservation Muslims were also accommodated. That obviously related to some loss of reservation to OBCs. That is a criticism here. Now let's see. In India, reservations broadly we will given on following areas. Here the context is reservations. Reservations generally it will be provided on following grounds. The first ground is educational based reservation. This is Article 15. Then employment based reservation. Employment based reservation. Article 16 it deals with. Political reservation. Political reservations are applicable at various levels. Political reservation in local governments and political reservation in Lok Sabha and Assembly. As you know that there is no reservation in Rajya Sabha and Council. So here these are the reservations applicable. Education reservations mainly Article 15 clause 4 and Article 15 clause 5. These two articles deals with reservations in education. Article 15 clause 4 included by the Parliament in response to Supreme Court judgment in the Champakam Dorai Rajan case. In Champakam Dorai Rajan case, Supreme Court given a judgment that there cannot be reservation in education based on the caste. To overcome that, Article 15.4 and later specifically to give reservation to SC, ST and socially and educational backward classes. Okay, to these people reservations in education, the Article 15 clause 5 added. Article 16 regarding the reservations, Article 16 clause 4 and Article 16 clause 4a and Article 16 clause 4b, Article 16 clause 6, Of course here also we have Article 15 clause 6 as well. Article 15 clause 6 and Article 16 clause 6, they are mainly related to EWS reservation. Here EWS reservation in education, EWS reservation in the employment. Article 16.4 it gives reservation in employment to backward class. Regarding this particular article, while Supreme Court giving the judgment in Indira Sahani case, Supreme Court observed that Article 16 clause 4 is not providing any reservations in promotion. To overcome that, Parliament included the Article 16 clause 4a. Later, to give reservation in unfilled vacancies, okay, whatever the jobs reserved to SC, STs, if they are not filled, then those unfilled vacancies will be carry forward to the next notification, and those will be only filled with the SC, STs, and they will not be included in the rest of the 50% ceiling. That provision was added in the Article 16.4b. Article 16.4b exclusively deals with the unfilled vacancies of SC/ST, okay, and BC as well. But Article 16.4a only SC/ST, not applicable to BC. There is no reservations in promotions in BC, that you have to understand. Article 16.6 is related to EWS reservation in employment. Now, one question to you is Article 15 clause 6, Article 15 clause 6, whether it is applicable to minority institutions or not. Minority institutions or not. Answer to this question, minority institutions or not. Article 15 clause 6. Now let us see political reservation. Regarding the political reservation in local government level, Article 243D, Article 243D is providing political reservation to SC/ST and women. Of course, reservation to OBCs in the local government is optional completely. It depends on the state government. Regarding the Lok Sabha and Assembly, in Lok Sabha and Assembly at the moment, we are practically implementing the SC and ST reservation through Article 330 and Article 332. SC and ST reservation we are implementing. Of course, women reservation is also introduced, but it is yet to be implemented. We know that women reservation, we are providing women reservation, that is through 106th Constitution Amendment Act. So this is about a reservation to SC/ST and reservations in general at various levels. Now we will see. So here OBC reservation, which is supposed to be based on social and educational backwardness, both at central level and state level, it included, okay, Muslim reservations in Andhra Pradesh, and some other states also they accommodated Muslims in the OBC reservations. That is a criticism of Prime Minister, okay, and the Muslim groups like Nurbash, Mahatar, these are included in the state OBC list with 7 to 10% quota. But actually the original demand in the United Andhra Pradesh, at that time the demand was all the Muslims should be given the OBC reservation. But all of them were not given, only few people they got the reservation as a OBC. According to the 2011 census, the Andhra Pradesh population, Muslim population was 9.5%. In 2004, then United Andhra Pradesh government given 5% of reservation to Muslims. Later, this decision of the state government challenged in the AP High Court. AP High Court struck down the quota because the state government did not consult the backward class commission and did not exclude the creamy layer and given reservation to all the Muslims. It is against. Because all you know that in the Indira Sahani case, Supreme Court clearly mentioned that in OBC reservation we have to follow the concept of creamy layer. In 2005, the state government brought a legislation giving 5% quota to Muslim again. Here, while bringing this law, state government justified its decision that the OBC population is more than 77% of the population, 77% of the population are more than OBC, and the further reservation to 5% to Muslim community in addition to existing 47% of the OBC, it will not going to affect the OBC. So here state government is given a clarity that additional reservation to women in OBC quota is not going to affect the backwardness of the OBC. That was the state government justification. In spite of this, again the High Court struck down the decision. Then government challenged this in Supreme Court. Now this case is particularly pending in the Supreme Court. The Supreme Court in 2010 it directed to maintain the status quo till the court has heard the issues. That means still the reservations are going on. Now it is sub judice, it is examining by the court. This is the actual thing. Regarding the reservation to SC/ST, already explained at what are the various provisions which are giving reservations. So how this Article 16.4a, it is providing SC/ST reservations in promotion. It was added through 85th Constitution Amendment Act 2001. And the backlog vacancies should be filled with respective communities, that is 16.4b, which was added through 81st Constitution Amendment Act 2000. Then Article 330 and Article 332 providing SC/ST reservation in Lok Sabha and Assembly respectively. Article 243d, SC/ST reservations in Panchayati, and Article 243t, it providing SC/ST reservation in municipalities. Article 335, actually this was asked in the 2023 UPSC prelims question. Okay, Article 335 mainly talks about that reservations should not affect the overall efficiency in the services. The same observation even made by the Supreme Court in Nagaraj case as well. In Nagaraj case, Supreme Court observed that the overall reservation should not affect the efficiency in the service, and the reservation should be given as long as the particular group of people are not adequately represented. Once they are adequately represented, then there should not be reservation. And even it went further step that Supreme Court also mentioned in Nagaraj case, there must be a creamy layer concept in the SC/ST also, like OBC. But it is not yet to be implemented because that was later overturned by the again larger bench of the Supreme Court. Champakam-Dara erosion case, because of this Article 16(4) added, we already discussed that. In reaction, Parliament added the Article 16(4). Indira Sahani case, Parliament observations, Supreme Court observations. Supreme Court clearly mentioned that there are no reservations in promotion, and to that Parliament added the Article 77th Constitution Amendment Act. M. Nagaraj versus Union of India 2006 case, Supreme Court observed following these three things: SC/ST reservations, okay, they should be socially and educationally backward, only those communities should get. They, as long as they will get, they are not adequately represented, and it should not affect the overall efficacy of the administration. Jarnail Singh versus Lachhmi Narain Gupta case 2018. In this case, Supreme Court mentioned that reservations to SC/ST should be based on the quantifiable data on the backwardness. That means before you are giving reservations, first you have to substantiate your reservation with the backwardness. If they are really backward, then only the reservations must be given. Creamy layer exclusion, it must be extended to SC/ST, and state cannot grant reservation in promotion to SC/ST. Of course, these were struck down and these by the larger bench. Next, so yesterday's video question. In the yesterday's video, we discussed about consider the following statement with reference to elections in India. The recommendations for the general elections is made by Cabinet, not exactly Election Commission of India. The notification for the general election is issued by the Ministry of Home Affairs. ECA will issue the notification. Next, today's video question. Today's video question is: prohibition is the act or practice of forbidding something by law. More particularly, the term refers to the banning of manufacture, storage, transportation, sale, possession and consumption of alcohol beverage. The description most appropriately related to which of the following DPSP? Pick the right one. Main question: how does reservations in local jobs hamper the ideals of right to equality and India as one nation as defined in the Constitution of India? So this is about how reservations in local jobs is affecting the right to equality across India. As we reach to the end of this video, we will do some quick revision. In this video, we mainly discussed about our Prime Minister comments about giving Muslim reservations which supposed to be for the SC/ST and OBC. We discussed about how these reservations are working out, reservations in education, employment and reservations in political sphere as well. Of course, along with this, we also discussed about some of the Supreme Court judgment as well. So this is the overall concept and detailed analysis regarding the reservations to Muslims and reservations in general as well. I hope this video is useful to you. Thanks for watching this video. Have a great day. Jai Hind.